My name is George Moxery. I'm the Vice President of the Fordham chapter of the Federalist Society. On behalf of Justin Ferguson, the President of the Fordham chapter of the American Constitution Society, and Justina Lopez, the President of the Fordham Law Republicans, I'd like to welcome you to today's event. Today's debate is entitled DC versus Heller and the Future of Gun Control Legislation. We're very pleased to have with us today Alan Gura. Mr. Gura argued the DC versus Heller case in front of the Supreme Court and won, striking down DC's gun ban, and he's currently involved in a similar case in Chicago, McDonald versus the City of Chicago, challenging the City of Chicago's handgun ban. Facing him is our very own Dean Bill Treanor, who's a constitutional scholar in his own right, and he'll be taking the other side of the coin. Our Professor Johnson will be moderating. I'd like to thank the board members of all three groups, the ACS, Federalist Society, and the Fordham Law Republicans, who participated in making this event possible. We have materials down here from all three groups, sign-up sheets for all three, and also some propaganda for you to take from one or both sides, whichever you should be interested in. We've got more propaganda, so. So without further ado, I'll turn it over to Professor Johnson.
Thank you, George. Welcome to all of you. It is a privilege to be here on the dais with folks who are doing and have done important work in constitutional law. I happen to believe that the topic we're going to be talking about today is one of the most important things that's gone on in the context of the Supreme Court in many years. It tests our commitment to rights. It tests our conception of constitutionalism. And today we will have an opportunity to hear two very smart and informed people talk about a subject that divides the nation in some ways. I will moderate. Our format will be 15-minute presentations by each of the panelists, and we'll have a bit of time after that for rebuttal if it seems appropriate. And after that, we will have hopefully a good bit of time for Q&A, an opportunity for you all to engage the folks on the panel, and I will try to keep it from being too frisky, but it's a place where it's probably appropriate for you to be a bit frisky. So as we start, I think the order is going to be Alan will proceed first, then the Dean will follow, and we'll proceed after that as I described. So let's get started.
Thank you so much for having me here. It's a pleasure to be here. Just by a show of hands, how many people here have read the Heller opinions? Just about everybody. Great. Well, I'm not going to revisit the debate back and forth as to what Justice Scalia had to say versus what Justice Stevens and Justice Breyer had to say. We can all go ahead and read that. But what is important to note is that the Supreme Court did finally resolve the question and decide that the Second Amendment is a normal part of the Bill of Rights and secures a meaningful individual right. I will try to address my commentary to what I believe is going to happen next, what I think is the future of Second Amendment litigation, and how this right that's just been announced is going to be applied in the future. The Second Amendment being a normal part of the Bill of Rights, we're not going to have, and we did not get, a case that tells us for all time when the state violates the right to bear arms and when it does not. Just like we don't have one case that for all time tells us what a reasonable search is or when government entangles itself with religion too much. Luckily for us, this is a subject of endless litigation. Cases will come up on a case-by-case basis as fact patterns emerge, and the contours of the law will develop in an organic fashion, just like it does in other constitutional areas. And of course, that means more work for lawyers, and of course, I think we can at least all agree on that, no matter what we believe about the Second Amendment. We can always use more work to do. The first question I'll address, which I think is probably the most important one coming up in the future, is that of incorporation. As you know, it's not enough that we have a right that's been announced by the Supreme Court that binds the federal government. The question here is whether or not this is a right that will also be incorporated as against the states and the local units of government as well. This is particularly important in the gun area because The fact is that most gun regulations and gun control and gun prohibition laws exist at the state and local level. There really isn't a whole lot of congressional law that addresses firearms. We have some basic firearms laws, but really most of the actions can be at the state and local level. So the question becomes, what do we do with the Second Amendment with respect to the 14th Amendment? And here Heller gave us a few clues. In footnote 23 of the majority opinion, the majority noted that it was not decided in corporation, an issue not before it, but that all the Supreme Court's incorporation precedent, such that it is relating to the Second Amendment, is kind of antiquated and obsolete. There are cases dating back from the 19th century, from the pre-incorporation era, which stated that the Second Amendment does not bind the states, but of course those cases also told us that the First Amendment doesn't apply to the states, that the Fourth, Fifth, and Sixth Amendments do not apply to the states. Clearly that's no longer the law. Those cases did not anticipate, did not know of the incorporation doctrine that was later announced by the court, and so they don't really speak to the issue. And the court, in fact, tells us that those cases are somewhat faulty because they lack the required due process analysis. And that word "required" is the Supreme Court's word, not mine, and that's an important clue. So what is the due process analysis? What is the path to incorporation? I'm litigating a case right now in Chicago against that city's handgun ban. Chicago has a handgun ban which is identical to that that Washington, D.C. recently had. That is, all firearms must be registered, and one may not register a handgun, therefore a handgun ban. There are also other laws in Chicago that the case is challenging that deal with the way in which registration is accomplished in that town. It is not a challenge to registration per se, but we believe that if you're going to have a registration program, then that program needs to comply with basic constitutional standards. It needs to be one that is respectful of the fact that there's a riot state. It can't be arbitrary and capricious, and it can't impose requirements that don't really advance any sort of government goal, but which merely serve to harass and tax what is a fundamental constitutional right. In arguing for incorporation, my case at least, first argues for incorporation under the Privileges or Immunities Clause. The Constitution, the 14th Amendment's first section, says that states may not enact or enforce any laws that abridge the privileges or immunities of U.S. citizens. And that was intended and meant and understood at the time to do just that, to make sure that the Bill of Rights, as well as other traditional civil rights, were going to be enforced as against the states, and the states could not violate the rights of newly freed slaves and Union veterans and abolitionists and so on. Those people could not be deprived of basic core constitutional rights. In the wake of Reconstruction, it was understood that the old regime of merely having the federal government bound by the Bill of Rights was no longer workable. And that's what the Privileges or Immunities Clause was intended to do. Unfortunately, in the first case interpreting the 14th Amendment, the slaughterhouse cases, the court read the Privileges or Immunities Clause out of existence. They came up with this funny theory that you only have the privileges or immunities relating to United States citizenship that flow out of American citizenship, such as the right to a passport, or diplomatic protection abroad, the right to the navigable waterways of the United States, the right to petition the Congress. And of course that's not what we fought the Civil War over. Everybody pretty much agrees these days that slaughterhouse was wrong. Not everybody agrees about the content of the privileges or immunities that are protected by the 14th Amendment. Some people, such as myself, other more libertarian-minded folks, believe that the Privileges or Immunities Clause protects not just the Bill of Rights, but also some very basic fundamental economic rights that were at issue at the time. The right to make and enforce contracts, the right to pursue a livelihood and engage in the common occupations of life. Some of our progressive friends don't necessarily agree that those rights should be fully protected by the clause, but they like other rights that they think need to have a more originalist basis. And so we now have an argument that perhaps abortion and contraception, those types of things are included in the PRI clause. While there's not an agreement exactly about its full context, most people do agree that at least the Bill of Rights is incorporated by the Privileges and Immunities Clause, and considering the unique history of the Second Amendment and how it was considered at the time that the 14th Amendment was ratified, I believe it would be irresponsible for me not to litigate that question.